Is roll call. June?
Councilmember Grossman?
I'm here.
Councilmember Anderson?
Here.
Vice Mayor Nye?
Always glad to be here.
Councilmember Mallory?
I'm here.
Councilmember Whiting?
Here.
Mayor Skoog?
We're here.
Thank you.
Okay, move on to new business number 3A. Boy, I don't know if I feel like reading that whole paragraph. No. Consideration of authorizing the mayor or in his absence the vice mayor to sign resolution number 2008 as an emergency measure to A, approve participation in and vote in favor of the debtors' first amended Chapter 11 Plan of Reorganization, jointly administered as case number 315BK1036, MCW involving Prescott Valley Event Center, LLC, and filed July 13, 2017. B is formally adopt, approve, and ratify that certain analysis of Prescott Valley Convention and Event Center community value dated July 20th, 2017. C, conditionally withdraw any claims filed in a bankruptcy case on behalf of the town. D, conditionally authorize legal counsel to consent to and approve any plan confirmation order issued in relations to Chapter 11 plan. E is approved collateral assignment of certain rights and remedies inuring from the amended intergovernmental agreement entered into July 20th, 2017 by and between the town of Prescott Valley, Arizona and the Entertainment Center Community Facilities District. F is conditionally approve the transfer of a liquor license assigned by J.A. Flats LLC to the Entertainment Center Community Facilities District under Chapter 11 plan. G, conditionally approve the payments required by the town in fiscal year 2017 and 18 under Chapter 11 plan. And H, conditionally authorize the mayor and staff to execute all documents necessary to implement Chapter 11 plan.
You passed reading.
Was that okay?
Here's your report.
Laura Lee says I read okay. I'm not sure what our attorney would say. Larry?
The mayor and council, if you'll recall back to the first work study meeting in June, we had laid out the reasons and the entire rationale for us being involved in the bankruptcy of the event center. And we had laid out the entire plan showing how we were going to save the citizens of Prescott Valley significant amounts of money while at the same time increasing the programming and the economic impact that the event center was going to have on the town of Prescott Valley. During that meeting, we said that there were a number of details, or actually I think it was Ivan that said there were a number of details that needed to be worked out. Well, working feverishly with team members that are in the audience this evening since that early meeting in June, the details have now been worked out. And with that, Ivan, take it away.
Well, thank you. You know, we've got some folks out there truly who have been a team with us that have helped us get through all of this process over the last 2 years. This evening, you're first of all going to be sitting as the town council. Later on, you'll be sitting as the ECCFD, the Entertainment Center Community Facilities District Board. In each case, you'll be taking some similar actions and some different actions. In particular, you're going to be, in both cases, participating, agreeing up front to participate in a Chapter 11 reorganization plan that has been worked out by a number of different parties, including creditors and debtors and other interest holders. And this plan is now out for a vote by all of the creditors. If everyone votes in favor, then there will be a hearing on September the 6th in front of a judge, and there's the possibility that that plan will be confirmed. And so this evening, you folks are authorizing, if you so choose, to participate in that plan, approve it, and conditionally take certain actions so that if that plan is eventually confirmed by the bankruptcy court, then our approval will already be there, and it will become effective on probably October 1st or October 2nd. That's if everything works out as anticipated. There are some scenarios that would happen if other creditors don't agree, and we've got folks who can talk about those details. But I'd like to start off, if you don't mind, by just introducing the team. Do you mind? First person is just sitting up close here, so we'll go ahead and let Jared Parker. He's with the firm of Parker Schwartz down in the Valley. You might remember him as our attorney, our bankruptcy attorney, when we were dealing with all the Stone Ridge Community Facilities District issues. And now he represents both the town and the Entertainment Center Community Facilities District with regard to all of the bankruptcy issues that we've been dealing with. And his advice has been invaluable in that regard. And he'll be here to answer your questions and kind of walk us through the whole bankruptcy process. Michael
Mr. Parker.
Michael Cafiso, you know Michael. Michael, why don't you, Michael, go ahead and stand. I hope you don't mind. Michael doesn't hunch over yet. He's an old man now. You remember him, from 30 years ago. If you saw him when he first came, helping us with issues of finance through bonds and things like that. Michael has just grown more distinguished as time has passed. And Michael's been heavily involved in coming up with the process of issuing the bonds that are critical to the bankruptcy plan. And it's been an unusual set of bond analysis because he's had to come up with a bond that will then be put in as the assets in the bankruptcy, which will then purchase other assets and will, in a very complicated process, replace the original bonds that are held by the creditors who are the original bond holders. And that has just, I can't tell you the brain damage that has been involved in trying to come up with that process. And Michael has worked with Linda D'Onofrio in his New York office to make sure that the bonds that are issued can be considered federally tax exempt. And that has been a real process, and we've appreciated all of the work that they've done with us. And then there's Bob Casillas there. Bob, you got to stand. I know you just want to do that, but you know Bob. Bob is still a New York Yankees fan, and we've not been able to cure him of that defect. But aside from that, Bob is also providing his expertise in coming up with this bond issue that we've just been describing, plus a potential additional bond issue of $2 million that we would then use for some immediate refurbishment that is needed in the building and the parking areas. So thank you, Bob, and he'll be here to talk to us about any details that we need to talk about. The documents you've got in front of you, I heard that someone said, gosh, these all read the same. And they're long and they're detailed. You've got your RFCAs and your RFBAs and then all those attachments. And there's a lot of history in there, which of course, I couldn't have avoided even if we didn't need it. I just have to throw that in there. But the neat thing about all of that is that it has a purpose in that it explains why the center has been so valuable to this community for so long and gives us the background and the rationale for all of the steps that we're now going to be taking. And each one of those agenda items has to stand on its own. That's why each one of those documents in many respects reads the same, or has a lot of the same background information. But each step will be kind of important. And this first one is a resolution where you're, as a town council, asked to consider a number of individual actions that will allow the town as a creditor and as an interest holder to approve this bankruptcy and to participate in it. So I'd like to kind of start with any questions you might have that you would like to, it'll help me know, given all the detail that's in these documents, what in these documents you'd like to have us talk about. If you don't have any particular questions, then I'll ask our bankruptcy attorney to get up and talk to us in general.
Anyone have any questions in 10 words or less? Laura?
I just want to clarify. At the hearing, even if all of the parties say no, it goes to the judge, or even some of them say no to go forward. It goes to the judge, and the judge is the final arbiter. All right.
Jared will
Just want
be
to
able to
make
answer
sure
that.
I understood that.
That is not exactly it. It's a little more complicated.
Okay.
And unfortunately, the answer will probably be longer than the reading of that opening paragraph. With a reorganization plan like this.
You know, lift the mic up just a little bit.
Sorry, is that better?
Better, yeah.
With a plan like this, in order for it to pass by vote, 1/2 of the creditors in number in each class and 2/3 of the creditors in amount of their claim need to vote in favor of the plan. If any class does not get that level of voting, then that class is deemed not to have accepted the plan. If a class, in order for the plan to be confirmed, and for the judge to have the authority to confirm it, there has to be at least one impaired, meaning a class that is getting less than what it's entitled to otherwise, at least one impaired class that ends up accepting the plan. So once that happens, that's a critical requirement. At that point, if all the other classes accept as well, you're fine. If there's any other class that does not accept, then that class has to be considered specifically by the judge. And depending on what type of creditor, whether it's a secured creditor, an unsecured creditor, there are different tests that must be satisfied for the judge to be able to, the expression is, cram down the plan over their objection. And I won't bore you here with the test that applies to each class, but it does come down to the judge ultimately deciding if there is a basis to approve the plan despite not having met the requirements of numbers within a class and the appropriate classes voting for the plan. But unless there's at least one impaired class that votes in favor, the judge can't do anything.
Any other questions, Ivan or Larry?
If I understand correctly, most of the plan work has been designed to get as many votes as possible. And the vast majority of votes deals with the bondholders. I think there are 300 plus bondholders. There is one other class, though, that is not real excited about the plan, and they may be the sticklers, and that's a class that claims $11 million in attorney's fees from prior litigation. Do you have any thoughts about the pros and cons, the likelihoods of what's coming up?
Yes, that class that we referred to, well, that particular, well, it's a class 2. The creditor Ivan's referring to is what we call the underwriters. They're related to the litigation that went on for years related to the event center. As Ivan said, they're claiming a reimbursement claim for $11 million for attorney's fees. And they have been set up as a separate class on their own in the case. And I think there is a basis for doing that because they are not like all other general unsecured creditors. There are aspects to their claim that make them different. Now, their class, which just consists of them, it will just come down to, do they end up voting yes or no? And if they vote no, then their class will trigger the need for a cram down process. And if the judge considers them as they are, as unsecured creditors, we think we have a pretty good argument as to why the plan should be crammed down over their objection. And there are other arguments related to them too, For example, there's a legal argument that their claim should be subordinated to everyone else's. That argument has not been raised yet by the Debtors' Council, at least formally, and hopefully won't have to be. But there are various weapons in the arsenal for dealing with them if they come around. But if they do not vote in favor of the plan, it could extend the time for obtaining the confirmation.
Yeah, I have a question. How many classes are there?
I believe there are about 14, and of those, by far the majority are likely to vote in favor or have already participated in the drafting of the plan.
Thank you.
Mary, you got a question?
Yeah, so there's possibly 14 classes, and the one that may be kind of the stickler could actually put the other 13.
As to each class, if they don't accept by the required numbers I stated earlier, and in this class it's a class of one creditor, so that's what I'm saying. It's going to be yes or no. If they vote no, then as long as there is a class that has not accepted, that triggers the cram down process. We have all the other votes tied up, all the other acceptances tied up, and then it's just a matter of convincing the judge to approve the plan over the non-acceptance of that one class. But yes, that one alone can trigger that process. But at least we then have all the other acceptances, so once the court deals with them, we're set to go forward.
And just a thought, hasn't all of the classes incurred attorney fees?
Well, some have, some haven't. I mean, there are a lot of unsecured creditors out there who probably have not hired attorneys in this case, although, and the classes, but I think the key, though, is the attorney's fees that they are seeking reimbursement for. The underwriters are the fees they incurred over the years in that litigation that went on for a long time involving all the parties, all state, and
I see.
And so that's where they ran up the attorney's fees, not in the bankruptcy.
Not
case.
recently. Many.
Yes.
Okay. Thank you.
Okay, Rick, question? No? Any other questions? Any other comments, Ivan?
Just want to give an opportunity for Michael, if you don't mind, to come up. Thank you, Jared. Michael, would you come up? And one of the challenges has been putting together of this bond issue, and it's been a unique process. And one of the documents that was put together that's in your packet is an analysis of valuation that was put together with the history of the facility and all of the various ways that you can look at value of the facility. Probably, in my opinion, one of the most interesting documents in the whole packet. And I just wanted Michael to be able to talk to us a little bit about that as he's put the bond issue together with his firm, and answer any questions you might have about that.
Good. Michael, greetings. Good to see you.
Mayor, members of the council, good to see you this evening. I can't not take the opportunity after Ivan made that nice introduction to say a couple of things that I would like to say, and that is I'd like to thank the town and its citizens and the council for allowing me to work with you guys for the last 30 years. I think back to some of the things I've done in my career, which is starting to come to its end, and the most interesting ones have been the ones I've done here. And Larry and Ivan have been around, and I think the mayor's been around for most of those. It started back in the late 80s when we actually needed to put a sewer system in all the downtown area. I won't make this long. I just want to give you a couple of really good ones. We needed to put a sewer system downtown, and people didn't really want a sewer system, but they did want streets. So we put the two things together, and we did 4 improvement districts. I think it was sort of unheard of at the time. Mr. Casillas helped with that program, and we successfully pulled it off. There were lots of late night hearings and a lot of other things that we had to go through to get that done. A lot of people didn't think it would happen. So that was an interesting introduction for me to one of the first things I worked on in Arizona. The other thing we can't go without mentioning is the acquisition of the water company. That was up to this point, and I'll I'll say why in a minute, but up to this point was probably the most unusual transaction I worked on. I mean, we went to Washington, D.C. I still remember flying with Ivan and others on airplane. I guess you didn't go on that flight, did you?
I did.
You did? Yeah, you did. Actually flew and met with the IRS in Washington, D.C., got a private letter ruling, ended up issuing bonds and buying the water company from the Fain family and saving the town at that time millions of dollars in the structure we were able to come up with. So again, I appreciate the opportunity to have worked with you, and now we're here doing something else that is probably the most unusual thing I've worked on in my whole career, literally. I mean, and it's Ivan is being a little bit humble, I think, in the way he describes it. I mean, it's been a monstrous task. I mean, we'll have meetings, telephone calls where you literally have 12 lawyers on the calls. If that doesn't sound like a nightmare, I don't know what one would be. But all of them have issues. All of them are representing fairly strongly their clients, and so they get sort of interesting. I will say that it's been interesting because my experiences with Ivan have always been pretty collegial, but I've seen Ivan in this process really kind of get a little bit testier than I'm used to seeing it, and that was good because it made a lot of us think. And
you haven't seen nothing. Go ahead.
I probably haven't, but it made us all think and made us come up with ideas. And Ivan said this just can't be right. We'd all go back and rethink it and go, yeah, he's right. It can't be right. So we got to figure out other ways to do things. So that kind of brings us to what Ivan was talking about. So one of the things that's unusual in this transaction, and again, I always warn you folks, this is like watching paint dry on a wall, so I'll try to make it as painless as possible. But one of the things that's real interesting in this transaction is that to make it work, we couldn't sell bonds and get money and then buy the event center. That just wasn't going to work for a lot of reasons. We could go into all those reasons, but it just wasn't going to work. The majority bondholder, that's not what they wanted. They had different ideas. They wanted a different kind of bond, basically, for the kinds of bonds that they currently have. So we had to figure out some way to do a transaction that didn't involve bonds for money. We had to figure out bonds for something else. So what we decided was, okay, it could be bonds for the assets that make up the entertainment center. So basically, the Community Facilities District is going to give $16 million worth of bonds to the bankruptcy, basically. It's kind of a feral sort of thing when you think about it, but they're going to give $16 million worth of bonds. The event center is going to get back basically the interest in the real estate, the interest in the building, the interest in all the contracts, the interest in all the equipment. So one of the things we had to do then is, okay, we just can't give bonds for some undefined amount of value under the Internal Revenue Code. So that's where the tax lawyers got involved. So the tax lawyers said, okay, this is easy. We'll go out and get a valuation. So this was 3 or 4 months ago. We started talking to all kinds of valuation experts, the kind of people you would think about. We talked to appraisers. We talked to specialized banks and said, give us a value of this thing. And they weren't as thoughtful as Larry Tarkowski is and saw the vision here. They just said, well, it's a building sitting on a little piece of land, and it hasn't been very successful to this point. We can't give you a value. Or else they gave us numbers that were just silly. I mean, it just wasn't working. So the lawyers in my firm, the tax department, after Ivan said there's got to be a better answer than this, they went into a room, 3 of them, very smart women, all women, and said, okay, here's another idea. And so what they decided was we can come up with a valuation based on the present value of the future revenue streams from the development agreements. So if you guys didn't have to continue to make payments under the development agreements, and instead you could keep that money, that's a value in you now owning the arena. Because if you own the arena, you don't have to keep making those payments. So again, Ivan was very humble because he wrote the report. It's his work. The tax lawyer and I, to a certain degree, editorialized just to make it work the way we thought it needed to work. But that's Ivan's work. Ivan put that together, did a wonderful job. Actually, Ivan doesn't even know this, but another tax lawyer in my firm read it recently, and unsolicited said, that thing is great. It's perfect. We really have exactly what we need here. So again, what that report does is it looks at all the things you would have been paying for the development agreements and other things in the future. We perform an analysis we call present value. It basically bring all that back to what it is, what's it worth today. We took into account the expenses for the bonds that are going to be issued, because you're going to have to pay debt service on that $16 million worth of bonds that the district's going to issue. And we did some subtraction, did some more math, and we came up with a number that was a reasonable enough number. Now what we do with that number is that before we close the bond issue, we'll actually go into the bond markets and we'll say, okay, if we were going to sell a bond that we're really not selling, we're actually giving up for assets, what would that bond be worth? And Bob's firm is going to help us do that. Mr. Casillas' firm is going to help us do that. And we're very comfortable at this point that the number he's going to give us is going to be less than the value that shows in the report that you're going to approve tonight. And that's the evidence we need to be able to say it's fair value for the amount of the bonds that are going to be issued. So again, it's like watching paint dry on a wall, but exciting for old guys like me that do this kind of stuff. And again, it was kind of interesting doing something we don't do on a regular basis. And of course, it had to be Prescott Valley because you guys always have to do stuff that nobody else has done. So that's the explanation.
Questions, anyone?
You know, as always, Michael, in fact, is the one who's being modest because he was the one who pulled all of that together with all of the people that were involved. And we appreciate it very much, his firm and their efforts that they went through to pull together what was the most important part of the entire transaction. Thank you, Michael. We appreciate that very much.
Thank you, Mike. I appreciate that.
And Bob, you want to just come up and talk to us a little bit about some of the things Michael was saying there in terms of how you're going to get that priced, and then talk to us a little bit about the additional financing through a private placement to help us get the parking lot and other areas worked on?
Good evening, Mayor, fellow council members. Appreciate the opportunity to be here tonight. And again, kudos to obviously to Mr. Tarkowski, Mr. Legler, Mr. Cafizo and his firm, and others that have been involved because they've obviously done the bulk of the work. We stand ready when we are at that point in time to do that analysis, as Ivan alluded to, and assuming all of that comes into place and the necessary approvals. I believe one of the other items that you'll be considering later tonight, and Ivan just alluded to it, is the potential of issuing additional bonds for some refurbishment improvements to the event center facility, whether it's parking and some other identified projects, roughly $2 million. It would be a similar process. Recall the last time I was here, maybe a month ago, as it related to the police expansion renovation project, where we, with your approval, allowing the financing team to go forward, we went out to approximately 15 different financial firms in that instance, and we envision a similar process for that additional $2 million. And we actually are looking to next week to close that transaction, the police expansion facility renovation, and have the monies available for that construction project. That rate that we were able to garner is 2.3%, which was a lot less than our conservative, albeit number that we provided maybe a month ago. So we're very happy with those results. Again, we haven't closed the transaction yet. There are still some other documents that need to be finalized, but we envision a similar process with that $2 million, assuming everything falls into place. We would go to most likely the same financial institutions and have the same process and hopefully have a similar result as well. So we're excited about that. And I just wanted to, for the record, preceding the introductions by Mr. Legler, I am first and foremost a baseball fan, secondly a Yankees fan. So with that, I want to thank you.
Thank you, Bob. Any questions of Bob?
Thank you. Mr. Mayor and Council, then if I could, I just want to talk a little bit about the vision of all of this. As you know, it has been a long process. We started clear back in 2004. In 2005, there was a great deal of excitement as we entered into the development agreements. In 2006, the CFD was created, the facility was built, it was starting to be occupied. It was an exciting time. It was a different approach. You'll recall that the approach was not that the town or the CFD would be issuing bonds. Rather, we simply had a development agreement whereby we would use specified revenues to help with the payment of bonds, but those bonds were obtained by a private party. and hopefully the bonds were going to be paid largely from revenues that were developed by the facility. The challenge, of course, was that then the worldwide recession came in, and the facility wasn't able to produce those revenues. The town continued to function and do its work, its obligations under the development agreements, but those were not sufficient to make full payments. And in the end, there ended up being a 5-year litigation process from the bondholders, and then there's been the bankruptcy filing by the private entity that put forward those bonds. There were a lot of approaches, a lot of thoughts about how the thing could be fixed or resolved. And it won't surprise you that the impetus, the primary moving factor behind continuing to find ways to make this facility keep moving ahead and keeping its doors open was largely the town manager. The town manager and his efforts to continue to find ways and explore ways to do things. And one of the things that helped us in that process was when we learned in March of 2016 that the majority bondholder that had sued us before, Allstate, had then sold its interest to another entity called Lapis for pennies on the dollar. And that entity then came to us and talked to us about how we might then redo the deal for their benefit and the benefit of the community, so that we wouldn't continue to operate under those development agreements we'd entered into back in 2005 and prior, but would pursue something new. And that new approach would involve the Community Facilities District then owning in full the facility and hiring an entity or working with an entity that had already been hired to operate that facility. And so it would be, I think, useful for Larry just to talk to us a little bit about that process, help us understand his negotiations with Lapis, and then the process going forward from here of operating the facility.
Probably very important to point out, and also a shout out and a thank you to Lapis. Lapis went in, they're a company that buys distressed bonds in many locations around the country. And in all honesty, if it weren't for their effort going ahead and buying out Allstate's interest in the arena, we would not be sitting here today having the conversation that we're having. The likelihood of the arena going into a Chapter 7, meaning the doors closed, would have been much greater had it not been for Lapis. And so a shout out to Kirsten and her team, Joe in particular, that they've done a great job for the community, as they have other locations around the country. Some people might criticize them because they do this as a business. They're going to make money. Well, bravo for them, because if they weren't, then we would still end up facing a potential Chapter 7 bankruptcy. Bill Copey and I met with the Lapis team, negotiated some deal points, and came up with a long-term financial plan that has the potential of delivering savings to this community that are significant over the life of the agreement versus the development agreement that was in place. Those numbers range anywhere from $18 to $22, $23 million that we potentially could save. We don't know exactly what that number is, but we're talking significant amounts of dollars. And so to that end, we thank Lapis, and not without some hard negotiating. That is something that certainly Ivan was on the forefront last week, and but it's all coming together finally after about 2 years of a process. The light is very close at the end of the tunnel.
Good.
And just to put a final point on that, that negotiation process actually involved Jared Parker, some late nights, long days and negotiations. at the very last minute, as you might guess. Some of those details, we were very close and still kind of far apart. And he was able to almost, with Michael, single-handedly pull that together at the end. And so we truly appreciated the fine work that he and Michael both did in that process. All right, so that's all the background. There are a number of actions that are going to be proposed for both the Town Council and the District Board. This first one, Resolution 208, has a number of parts to it, but it's essentially to authorize the town to participate in the plan, to approve the plan, and to authorize its legal counsel to sign the confirmation order if that happens in September or later, whenever that might happen, and to approve the purchase, to approve the transfer of the liquor license between the current operators, Prescott Valley Event Center LLC, to the CFD, and take other necessary actions. And so with that, Mayor, I'll see if there are any other questions that you have or that the council has, and if not, then we could probably ask for a motion.
Good. Any other questions, anyone? Laura? I think we are ready for a motion, I guess. Mm-hmm.
Motion to authorize the mayor and his absence the vice mayor to sign resolution number 2008 as an emergency measure, taking action to approve and have the town participate in the bankruptcy plan related to the event center by electronic vote.
Mr. Mayor, I'll second the motion.
We have a motion and a second. Everybody understand an emergency measure, I hope. June, there's been a motion and a second. Would you set the vote? Mine hasn't done it there, June.
And how would you wish to vote, Mayor?
I'm going to vote yes.
Thank you. I'll record that.
Okay, with that...
And that passes.
It passes, thank you. Okay, with that, then we'll move on to B, consideration of approving an amended intergovernmental agreement with the Entertainment Center Community Facilities District to, among other things, authorize the town payments necessary to implement the debtor's first amended plan of reorganization in case number 315BK10356, MCW of the U.S. Bankruptcy Court of Arizona. Okay, Larry, who's driving? You're going to start that one?
Mr. Mayor, if I could just explain, the CFD currently owns the facility, but there's a possibility of reverter. That is, that the title could go back to the current lessee of the facility, the entity that's in bankruptcy, Prescott Valley Event Center LLC. And so the desire is for that possibility of reverter to go away so that the title is fully within the CFD, the Community Facilities District. And of course, the Community Facilities District is the entity that's going to issue the bonds and put that in the bankruptcy estate in order for all of this to work. But as you know, the CFD is only within the boundaries of the property on which that facility sits. And so the CFD has no revenue. It has no way to obtain revenue. All of its revenue will come from the town through the intergovernmental agreement. That has always been the case with every one of our CFDs. And certainly that was the case back in 2006 when the CFD was created. What's been required in order for this process to work is for that CFD to be fairly significantly amended and to provide remedies for the bondholders so that they'll be able to make sure that the town makes its payments to the CFD so that the CFD can then make its payments to the bondholders under the new bonds. And so in each case, the town will approve the new CFD, the amended CFD, and then the CFD will approve the amended CFD. And so this is the second action that you're being asked to take as a town council to approve this amended this amended intergovernmental agreement with the Entertainment Center Community Facilities District.
Good. Questions, anyone? Mike or Marty?
I'll make the motion.
Okay.
Motion to approve an amended intergovernmental agreement with the Entertainment Center Community Facilities District to, among other things, authorize town payments necessary to implement the debtor's first amended plan of reorganization in case number 315BK10356 MCW of the U.S. Bankruptcy Court of Arizona by electronic vote.
I'll second.
Okay, with a motion and a second, would you set the vote, June?
And that passes, Mayor.
Thank you, June. Okay, we go on to number C, consideration of approving and confirming the earlier retention of Sean McLaren of Ball, Stanton, and McLaren as real estate counsel for the town of Prescott on behalf of the Entertainment Center Community Facilities District for the ECCFD to obtain the acquired assets under the debtor's first amended plan of reorganization in case number 315BK 10356 MCW of the U.S. Bankruptcy Court of Arizona. Comments, Ivan?
Mr. Mayor and Council, the assets that the bonds will purchase are that reverter interest that we just described, any of the contracts that are currently in place to operate the facility, like the SUNS agreement, and also any agreement that will have been entered into with Spectra to operate the facility. And then also the fact that PVEC will agree to let go its lease that it currently has with the facility. And so those are the assets that are being purchased, the assets that needed to be equal to the value of the bonds that are being issued. And again, Michael helped us understand. You see, we've lived with this facility for so long. Frankly, we think we understand it pretty darn well. But he reminded us that there are always some uncertainties out there, and that we needed to work with a real estate attorney who would make sure that we got a title report, a survey, and some other things that need to be done, just to be certain that we're getting a clean property for what we're paying for. And so this attorney, Larry, has already signed the agreement, and this attorney is working with us, but we'll be going beyond Larry's capacity of $16,000, so we need you to ratify that agreement.
Good. Questions, anyone? Well, Mike?
I'd be happy to make a motion, Mr. Mayor.
Okay.
Motion to approve and confirm the earlier retention of Sean McLaren of Ball, Santon, and McLaren as real estate counsel for the town on behalf of the Entertainment Center Community Facilities District for ECCFD to obtain the acquired assets under the debtor's first amended plan of reorganization in case number 315-BK-10356-MCW of the U.S. Bankruptcy Court of Arizona.
And I'll second that, Mayor.
Okay, June, we have a motion and a second. Will you set the vote?
And that passes, Mayor.
Thank you, June. Okay, I think we'll have to recess a little bit so that June can set up for the next meeting, the Facilities District meeting.
We need a motion to adjourn.
I'm sorry, we need a motion to adjourn first.
I'll make a motion to adjourn, Mayor.
We have a motion. Second, anyone?
I'll second.
Okay, with a motion and a second, will you set the vote, June?
Mm-hmm. And that passes.
That passed. Okay. Thank you, June. How much time do you need?